7178, and 7184 FH. It's time of day set for final pretrial. The defendant is in the courtroom, represented by attorney Karen J. Davis Roberts, who appears via the Zoom application. People are represented by prosecuting attorney Timothy J. Rakowski. The court has reviewed the court file, and it appears that we have motions to address, and I believe they would be, I reviewed this last week, so bear with me, but I believe they'd be Ms. Roberts' motions.
People would file a motion.
People, I stand corrected. Mr. Rakowski.
I do think, though, maybe the court's referring to last week we were in court arguing about the subpoenas. I don't know if the court's received the information yet at all from the medical.
No, we've received the proposed order.
Okay.
At this point. All right, this people's motion, go ahead, please.
Your Honor, Ms. Roberts has pointed out, I had a mistake in my motion because I put down the defendant file a witness list. It's actually May 2nd of 2025, not June 28th, 2024. That was before the charges. So she was correct on that. Our motion is motion to strike. The defense has listed different witnesses. I believe one witness, Mr. Lewis, is the same for two separate files or three separate files. But then there were two other witnesses that were listed on there. I got the response from Ms. Roberts, and for Mr. Lewis, she indicates that he is a private investigator, and that's fine, but we still have no address or phone number in which to contact him to see what he's going to testify about. The other two individuals that were listed were an Angela O'Connell and a Winnie Carl. And they're not relevant to the case unless the defense can somehow indicate how they're relevant. She indicates in her response that they're character witnesses. Well, is it character for truthfulness? Is it some other character? Because the different rules apply. So I just need to know which so I can argue effectively. And there still are no addresses or phone numbers for custody follow-up. And the motion, or excuse me, the witness list was filed on May 2nd, which is still within the time frame provided by rules. However, we're coming up to trial, which the trial date is June 3rd. So we're going to need those addresses and phone numbers so these people can be contacted. All right. The other part of it is for her expert that she's listed, MCR 6.201A3, expert witnesses.
Trial is closing in and the pressure is rising. Missing witnesses, hidden details, motions flying. Both sides race the clock because one mistake could decide everything.
We need a CV and a report or a written description of what their testimony is going to be. The people had listed a expert witness. However, at this point, we're just going to use that person as a fact witness and not as an expert witness. So we're going to withdraw our expert as it relates to Dr. Blaker. He's a fact witness. But as it relates to the defense, we still don't have a report or any written description.
Thank you. Counsel, your response, please.
Your Honor, I have filed amended witness lists and they were filed yesterday. I believe that Mr. Rakowski has received them. He should have, at least Ms. Hatch has acknowledged that she had received them. As far as addresses and phone numbers, no, I have not listed them. I did list addresses. Mr. Lewis is living in Florida. I'm more than happy to give the prosecutor the phone number of Mr. Lewis. I did not want to put it into a pleading so that anyone in the world could get that information. I'm more than happy to provide that to him. As far as Miss O'Connell and Miss Carl, they are character witnesses. And again, I'm more than happy to provide that information to him. And if he would have asked for it earlier, I would have given it to him. I would not put that in the pleading because I think it's sensitive information and it's not for the public's eyes. They are character witnesses. I'm sorry.
I'm sorry, character witnesses for truthfulness?
No, not necessarily for truthfulness, for whether or not there are a couple things, and one would be that um, whether or well, not as a character witness. I think that is about as much as I can provide the court without tipping my hand. I mean, they're not going to be able to testify to any of the facts, and I have listed that it's a character witness, and I do believe that it's relevant to the defense. Miss O'Connell is an ex-wife, and they had a relation. They were married for over 7 years and had lived together prior to that for several years. And I believe that her testimony will at least help the trier of fact make a decision about his character. And as far as Dr. Cruz goes, I'm not exactly sure what it is that the prosecutor's looking for. I explained that he has not written a report, and if he had, I would have obviously turned it over to the prosecutor. He has not written a report. He will just give testimony from the medical records that he's reviewed about the injuries, and that would be about the injuries that were sustained by Mr. Stevens.
How would that satisfy MCR 6.201A3?
I don't have the court rule in front of me, so if you want to tell me exactly what that is.
Sure, well, I'd be glad to. The curriculum vitae of an expert, the party may call at trial and either a report by the expert, which you don't have one, or a written description of the substance of the proposed testimony of the expert's opinion and the underlying basis of that opinion.
I really don't believe that it's necessary for me to provide that to the prosecutor. However, if it's something that is absolutely necessary, I will talk with Dr. Cruz and have him get it out within the next couple of days, depending, of course, on his work schedule, because he does work at the ER at Ford Hospital.
All right, well, under 6201A3, in addition to disclosures required by provisions of law other than MCL 767.94A, a party upon request must provide all other parties the CV of an expert. The party may call it at trial, and either a report by the expert or a written description of the substance of the proposed testimony of the expert's opinion and the underlying basis of that opinion. So the court requires that. And you said maybe within 3 days, depending upon the doctor's schedule. Can you stay in contact with Mr. Rakowski to try and get that information to him?
Absolutely. I will be leaving on vacation on Friday, so I will get it done before I leave.
All right. Mr. Rakowski, your response relative to all the other matters.
Well, as it relates to the doctor, that'd be great if we had that information. Also the CV, I would say before the court makes a ruling on this, maybe the court take it under advisement, because depending on what we get from the report or lack of a report, we may have to revisit this. I don't have to refile it. As it relates to the other individuals, I appreciate that Ms. Roberts will be getting us the addresses, but the other individuals would need to, or in the past, and what I've seen for defense prior to trial, is they will list off the witness address and phone number, because right now we just have Bad X, and there's a lot of people that live in Bad X, so we don't have the capability of going there to do that. And Mr. Lewis, same thing. If Ms. Roberts says she's going to get us a phone number, that'd be great, but we'll need that because she just resided in Florida, is what she said. And Florida's a big state. We need to have that so we can be ready for trial on June 3rd. because that's when the trial is set.
Right, exactly. And Ms. Roberts, you can do that?
I'll
I know
provide
you're
that. Actually, Your Honor, I have already provided the CV for Dr. Cruz. I sent that by email. I'm not sure if the prosecutor has received it. Should have.
When did you send it?
Yesterday
At the same time that I filed everything else.
Okay.
All right.
I check my email, not as often as I check my phone calls, so email is not the way to communicate with me unless it's, if it's emailed to the office staff versus email to me, but if Ms. Roberts said she sent it, then she sent it.
And I believe the prosecutor's office has a new email address for general filings, correct?
We're trying to do that. I believe that was set up. Yes.
Because I'm thinking in the future, we probably need to do that. At least,
But back to the court's response. So as it relates to the other two witnesses, though, Ms. O'Connell and Ms. Carl, I assume then, and maybe we can get verification on the record, she is not submitting these people as character evidence for truthfulness or untruthfulness.
can you answer that, counsel?
Not at the moment. I can't. I will get that information to the prosecutor. I will also speak with those two witnesses and about their testimony, and then I can get back with Mr. Rutowski.
But this is the challenge, though, because I've been on trial by ambush before, and I know at the last hearing, Ms. Roberts said I don't want to give any information as it relates to these subpoenas because I've given away my defense. I understand that, but it puts us at a disadvantage because if it's 608, that's one thing. If it's MRE 404, that's another one. We're dealing with character evidence. We need to know which way it's going to be presented so that we have the ability to properly respond. There are two separate rules. We have two separate requirements.
I don't disagree regarding all the rules here, but I'm going to require the information be provided by this Friday. If it is not provided adequately Friday, Mr. Rutowski, you can just renotice it. You don't have to file an additional motion.
Yes, Your Honor.
Just simply renotice it, and then we'll address it at that time. But I'd like to have these matters resolved before the trial date.
Yes, Your Honor.
I don't want to have any issues where we're in the course of jury trial and we have to excuse the jury for time to take testimony relative to whether witnesses are included or excluded. That's my preference.
And that's not a problem. And for Ms. Roberts' benefit, I just want to know if I have to renotice it, I don't want to renotice it while she's unavailable. So if we have a date when Ms. Roberts will be back available.
Ms. Roberts, do you know when you'll be available at least to address matters in the court?
I think that I'll be back on the 25th, but that's a Sunday. However, I'm still available, and I'll unfortunately be taking this file with me. But I'll be available by my cell phone and also by email. So it's not like I'm going to be in Greenland somewhere.
And that wasn't as it relates to Ms. Roberts being unavailable for our conversations because we could contact her. It's in case we have to renotice it. We want to make sure we don't renotice it to a time when she's gone.
Well, I can tell you what the renotice date will be.
Day before trial.
That's the only time we have
Okay.
with the holiday upcoming.
Your Honor, I do have an issue regarding criminal jury instructions. Would this be a good time?
Did you file a motion relative to that?
No, I just whether or not you want, at what point do you want the criminal jury instructions? Do you want them
Okay.
before trial?
Yes, I require them 14 days prior to trial. And I also require that you send them via email in Word format to the circuit court email address from 2.1 forward. And obviously filling out all the pertinent portions as if you were the judge reciting the instructions to the jury.
Okay.
Any other questions on that?
No, so send them to the court 14 days prior to trial.
Right. They must be received to the court 14 days prior to trial, just to speak correctly. And you can send them via email to the,
Okay.
and we'll the circuit court email address I think you've utilized before because obviously you filed documentation there. Make sure though, when you send the proposed jury instructions that they are in Word format, not in PDF format.
Right.
Because as you see on the screen, you're looking at the law clerk that prepares the instructions. Me, I prepare them
Oh.
myself.
Okay.
That's why I require it.
Okay. So if one of us, either the government or myself, has a problem with any of the jury instructions, like if I object or the government objects to it, what do we do from there? Would that be prior to picking a jury or?
Well, I think the standard initial instructions and the 2.1s forward, all the court does are the standard instructions, and the court also lists the charges and the elements required of each. I don't know, because again, I don't know any of the evidence of the case, but by submitting those instructions in advance, I can kind of parse through that and see where we're at. And if there is an issue prior to trial of the instructions, because we'll be meeting here on Monday, we can address it then.
Okay. That's the other thing. We're going to be meeting on the 2nd of June.
Well, yeah, only if you have motions. If there are other motions that need to be addressed, I'd rather have them addressed the day before trial rather than the morning of.
All right. So right now, you are not going to see my beautiful face until June 3rd. Correct? At
Yes.
9 o'clock.
Yes.
I want to make
Now,
sure I'm time.
when I talked about any other motions, I mean, today is the motion cutoff date because
Right,
it's the trial. But if it's regarding instructions regarding the trial itself, great. But the issue relative to the motion filed by the people is preserved because we don't have the information going back and forth yet. But if it's provided, great. If not, we'll address it on that Monday before trial.
All right. And I'm hoping that the government will please let me know if you did not receive Dr. Cruz's CV.
A prosecutor's office will do that. If we didn't receive it, we'll let her know.
Thank you.
Anything else by either party?
Not on behalf of people.
Not on behalf of the defendant.
Bond continues as previously set. And maybe we'll see each other the day before trial. That'll conclude the matter.
Deadlines matter. Details matter more. In court, surprises don't win cases. Preparation does. Before the trial even starts, the battle is already being fought.